Again, welcome. I'm delighted that you're able to join us today. This webinar will be divided into three sections or three parts. The first part will cover statutory schemes, and the second part will cover supervision and implementation. Following each segment, you will have an opportunity to answer and or ask questions throughout that segment. Many of you submitted questions prior to when you register, and we'll likely answer them during the course of the webinar. The presentation that we are really delighted to have you be a part of, and we're delighted to have two subject matter experts, Judge Douglas Hatchimonji, Superior Court of Orange, Judge Stephen Manley, Superior Court of Santa Clara. It is important to note how each county handles these particular cases will be unique and different. How you choose to handle them will reflect your own court and the work that you do. Following the webinar, you'll receive copies of policies and procedures for handling and San Diego. I assume that many of you have already developed your own policies or are in the process of developing your own policies and procedures, and we would also look forward to you making those available at the time. This webinar is not intended to direct you, but it's intended to provide you with some information that will inform your processes and procedures that will be more effective in handling veterans and the people that you serve. Before we begin, I would like to ask you to think about questions that you would like for us to address. Again, many of you have submitted some questions, but think about those questions. And as you go through the webinar, if those questions should come up, take a note and keep those in mind. Again, we are really delighted to have you here today. I'm going to quickly just highlight what I've just mentioned. It's parts of this webinar that will help you move through. And now, it is my honor to introduce Judge Hatchimonji.
All right, good afternoon, ladies and gentlemen. Just a couple of comments before we get into the substance of our discussion today. The first is neither Judge Manley or myself intend to provide any definitive answers to issues that are involved in this particular statute. At this point, it's a brand new statute. The law is evolving on it. There are not, at least to my knowledge, any Court of Appeal decisions interpreting the statute and its various provisions. So essentially, there are really no right or wrong answers when it comes to these issues. What we intend to do today is to provide to you multiple interpretations and approaches for the issues presented by this statute. It will be up to each one of you judges to exercise your judgment and discretion in making a determination how you will rule on these particular matters. At the end of each segment, we will look to get questions and comments on each segment, and hopefully if we have time at the end, we'll open up for further questions or comments at the end. However, and I have to catch up to where we are now on our little slideshow, time is really of the essence today. We have a lot of ground to cover. We're going to be flying along. Please excuse us for speaking fast if it turns out that way. Also, please excuse us if we end up kind of cutting you off in some of this Q&A up here, because we want to stay on track as far as our time is concerned. So the segment that I'm going to address at this juncture is the statutory scheme itself. And I know, judging from the some 50-plus individuals that we have on this webinar, that there are individuals who are probably really familiar with what the statute provides. Penal Code Section 1001.80 provides for a pretrial diversion of misdemeanor defendants who were or currently are members of the United States military and who may be suffering from sexual trauma, traumatic brain injury, post-traumatic stress disorder, substance abuse, or mental health problems as a result of his or her military service. This is for the eligibility part of this particular statutory scheme, it carries with it, at least in my view, some interesting legal issues that we need to consider. The first legal issue that we'd like to talk about is the burden of proof, and who has that burden of proof. The statute uses the term defendant may be suffering from one of the listed conditions. The question becomes, what does that term may be mean? Is it a preponderance of the evidence? If you take a look in the dictionary as to the meaning of the term may be, it suggests something along the lines of perhaps or possibility. The question is not answered by the statute nor by any cases. Personally, I use a preponderance of the evidence standard. I think it's an appropriate standard of proof. It's our lowest standard of proof in the law that we generally recognize. The next question really is, if my viewer will work, if I can't advance my page. The next question that we have here is also who has the burden of proof. There we go. Who has the initial burden of proof on this particular matter? A companion statute that many of you are familiar with, 1170.9, expressly gives the defendant the burden of proof of showing they fall within the meaning of the statute. 1001.80 doesn't carry that same language in it, but in my view, at least, in looking at the statute and entertaining the statute, I have held that the defendant has the burden of proof to show by a preponderance of the evidence that he or she may be suffering from one of the listed conditions as a result of their military service. But again, it's not real clear within the meaning of the statute. Another significant, in my view, issue of the statute is the meaning of the term as a result of his or her military service. Let me give you some hypotheticals here to consider. We're not going to discuss the hypotheticals because we don't have the time, but I think what they do is they highlight how different interpretations of this result of a language may yield different results when it comes to making a determination as to whether or not an individual is eligible to be diverted. So the first one is an individual who is off duty on base. Let's say they're a Marine on camp and gets into his personal vehicle. He's on base, rolls his vehicle on his way home, suffers traumatic brain injury, and eventually self-medicates with methamphetamine and is charged with 11377A of the Health and Safety Code. Or perhaps a nurse is deployed in Afghanistan, again off duty, but in her on-base housing, returns home and commits a PTSD related 273.5 domestic violence event. The third hypothetical, for instance, to consider is a defendant who testified in a motion to divert him that drinking heavily on base off duty was an expected part of his unit culture, viewed by a superior as a critical part of unit integrity. Develops substance use disorder, is arrested for a third DUI. I suggest you, if you look at these hypotheticals, depending upon how broadly or how narrowly you interpret the language as a result of his or her military service, you may get different results under these various hypotheticals. So, question, is it simple but for causation, which is pretty wide open, but for the person's involvement in the military, is their condition result from their military service? Do we use a sort of a traditional proximate cause substantial factor standard proof? For those of you who may have had some background in workers' compensation, you'd be familiar with the language arising out of and in the course of employment. Is that the standard when we're talking about as a result of their military service? I'm aware that some courts find that the condition must be due to an event that the defendant saw, did, or experienced in the performance, the actual performance of their military duties. The Department of Defense uses the term line of duty. The Veterans Administration uses the term service terminology essentially involves an individual who suffers the illness or injury while they are on active duty in the United States military, not necessarily at that moment carrying out a military assignment, but that it arose while they were in or on active service. So under that, under line of duty or service-connected definition, some of our hypotheticals would certainly bring a person within the meaning of the statute. But all of those hypotheticals posit that the person was off duty at the time that they suffered the injury, and if you interpret the statute to require that they were performing military duties at the time that they suffered injury, perhaps you would not divert them. I would suggest, however, that and again, there is no appellate decision with respect to the meaning of this language, and I would suggest that in your own exercise as a judicial officer that you decide what this is going to look like so that you can apply the standard consistently in your ruling and your decisions on this matter. If you do make a decision a person is eligible, that the person has suffered, is or was a member of the United States military and suffered a listed condition as a result of their participation in military duty, you still have the ability, you still have to make a discretionary decision as to whether or not to divert the individual. Subdivision B of the statute provides that the court may place the defendant in a pretrial diversion program. I would suggest to you that the exercise of your discretion as to whether or not to divert the individual utilizes some of the same considerations that we usually use in the exercise of our discretion in criminal matters. So we would look at public safety issues. What is the specific nature of the offense? How are we appropriately holding the defendant accountable for his or her conduct? Victim-focused issues in the matter, including issues like restitution. Are we, through this decision, reducing recidivism and thereby ensuring public safety? I believe that for eligibility purposes, a causal connection between the listed condition, CBI, PTSD, etc., a causal connection between the listed condition and the crime does not have to be shown. 1170.9, for instance, expressly requires a connection between the offense and the condition. 1001.80 does not have that same language in it. However, in my view, whether or not there is a causal connection between the listed condition and the commission of the crime is a relevant consideration on the issue of whether or not you should exercise your discretion to divert the individual. Because this is a treatment-focused program, this is a treatment-focused diversionary program, we want the treatment to be able to reduce the potential for reoffense. If we're treating a condition that doesn't have a connection to the crime, then are we servicing the issues having to do with recidivism and reducing recidivism? There are sort of general interest of justice issues, at least in my view. Problems of proof for the prosecution if the defendant fails and is terminated from diversion. If we're 6, 12, 18 months down the road from diversion and you terminate them because this is a pretrial program, the district attorney's office is going to have to gear up their case and be able to prove their case. The question in my mind is to whether or not restitution is available for this sort of pretrial diversion program. And again, I think that's a relevant consideration. Clearly, certainly when we're talking about DUI cases, the issue about fireability is a question that has to be considered in this particular matter. Lastly, the question is whether or not it is more appropriate to provide for post-conviction veterans-focused relief under 1170.9 of the Penal Code and and or having the defendant enter a Veterans Court program if your county is fortunate to have a Veterans Court program. Lastly, the last issue that I'd like to address at this juncture, we see the number of questions having to do with DUI cases and whether or not DUI cases are divertible under 1001.80. For me, I have had the prosecution cite two statutes for the proposition that DUI cases are not divertible. One deals with section 23640, which is noted in relevant parts, and also Penal Code section 1001.51. The express language of 23640 clearly seems to preclude the suspension or staying of proceedings and the dismissal of a case when we're talking about DUI cases. And I'm not going to go in, it would take too long to go into at least my legal reasoning, but I found that neither one of these statutes bars diversion. The 23640 issue, I believe, raises statutory interpretation and conflicting statute interpretation and the laws that govern interpreting conflicting statutes, whether one statute or the other is general versus specific, and whether one statute or the other, which statute was enacted before or after the other, and arriving at a conclusion in that regard. I also found that 1001.51 doesn't apply because that code section is in a different chapter of the Penal Code than 1001.80. If anybody's interested in receiving a copy of the written ruling that I did on these issues, so please feel free to email me. And I neglected to mention earlier, because we are so tight on time, if there are questions that you have that we are not able to respond to in the interest of time, please feel free to email Judge Manley and myself, and we will do our best to answer them if we can. At the beginning of this PowerPoint and at the end will be our email addresses, so you can go ahead and do that. So if anybody wants to know the legal reasoning on the DUI issues, please feel free to email me. So having to do with this particular segment of our presentation, simply having to do with the statutory scheme, issues having to do with eligibility and what I sort of call suitability and the exercise of your discretion. Is there anybody on our webinar that would like to ask any questions or make any comments? And if you do, then unmute your phone, and shout it out. Hearing nothing, in the interest of time, and like I said, if we have time at the end of our webinar today, we will go ahead and open it up for overall questions. Let me then pass this matter on to Judge Manley, who is particularly suited to discuss sort of issues. Once you've made the diversion decision, then what? Judge Manley.
Thank you. All right, so what happens next? What I'm going to suggest that in these cases, it is really a good idea to have one judge take on the responsibility of monitoring and supervising the diversion. If you're fortunate enough to have a Veterans Treatment Court or a Veterans Court in your jurisdiction, then I would place the supervision and monitoring there. It can be on a separate calendar or the regular calendar. That would be up to the judge who is there. And the reason being because the judges in the Veterans Treatment Court have all the connections and treatment with the Veterans Administration and are very competent and capable of making things happen. And that's very important in this particular statute. To begin with, I suggest you want to make sure if you're starting out that you have a treatment plan. And the reason is this, because the diversion's been granted because of a specific condition. Let's say it's PTSD. That's the issue that needs to be addressed. There may be more than PTSD. There may be substance abuse. There may be TBI as well, all of the same individual. But those are the issues that need to be addressed. And if you don't have a treatment plan, from the provider, that is the agency, organization, or individual who's going to provide the treatment. You do not have a benchmark to score how they do. Are they benefiting? Are they progressing? Should they be disqualified? So you start out with a treatment plan. Then you want to figure out whether or not you are going to use the one judge, and I suggest it always be the same one, or the Veterans Court. You have to have that judge hold hearings, and I'll go into that in a little while about the frequency of those and the importance of them. And they're not hearings in the sense of whether or not the person's benefiting at that moment. It's to find out what progress, if any, they're making, whether they're doing anything at all, and how far they're getting. I suggest to all of you that utilizing a collaborative treatment court model is the best way to go, and I emphasize that because you're not going to make this program work if you cannot bring all the stakeholders together, and that's going to be the Veterans Administration, local veterans treatment providers, say the vet center. You may need, you're going to need obviously the prosecutors and defense. And if you don't get anyone together, it's really hard to manage people on diversion of this kind, particularly because some of these cases are going to be serious misdemeanors. Another issue that I think is very important is to address HIPAA immediately. Now, this is the confidentiality. For those of you not familiar, federal law guarantees, it protects the individual as to their personal information, and that's what you're going to be dealing with. And I strongly suggest that you have each and every person granted diversion sign an authorization for release of all information relating to their treatment to the VA and from the VA to the court and to anyone else that's important, as well as any treatment providers, so that you have a general release of the information. Now, how do you then connect all of this with the Veterans Administration if you need to have them, and you most certainly do, in my view, involved? I suggest to everyone that you get familiar with the Veterans Justice Outreach Program. We call it the VJO. And these are specialists. They're employed by the Veterans Administration. They are there to help the court, to come to the court, and to assist you. If you can't find one by calling your local Veterans Administration, let me know and I will put you in touch with one, because they're throughout California and they are there to help you make these things happen. It's, again, the Veterans Justice Outreach Specialist. So let's move on to supervision on diversion services and resources. To begin with, we start with the Veterans Administration. They are often called hospitals, but it's really just the VA. Again, this is where you're going to find those outreach specialists. They are the major provider, in my view, of the specialized treatment that most of those on military diversion need. Then there are the Veterans Centers. They are separate. They are generally in each county, and they are federally funded, and they provide some of specialized programs. I have found, for example, in PTSD, they offer classes in anger management and things of that nature. You have the County Veterans Service Office. That is run by the county. It's state funded primarily, it's also county funded, but they provide more of a referral basis or source for you than specific treatment. Your main treatment providers outside of the local area are going to be the Veterans Administration and the Veterans Center. I do want to bring up one new program now that was approved by Congress last year, and that is the Veterans Choice Program. Veterans Choice Program, you see it listed there, and I call this program the 30-day, 40-mile program. There are long waiting lists for treatment, usually at the VA. It is difficult to get anything accomplished. There's a huge bureaucracy. However, if the veteran does not receive treatment within 30 days of asking for it, and that's what you order them to do, go out there and get it, or the veteran lives 40 miles away from the Veterans Administration facility, they are entitled to a Veterans Choice card. And there's a 1-800 number to get it. They get that card, and then they can go to a treatment provider in the community. And this is very important because you don't have that long to get these people through the diversion program. 1 year needs to start right away because these are cases that could go back to trial, and you want to make sure you're making every effort to move them through the program. You also have treatment available through the county. The statute is very specific. The county has to agree to this. They have to provide a treatment plan. They have to give you reviews. There are a whole lot of things the county has to do. Most counties should be in agreement to do this as long as they're not asked to spend any additional funds or provide services that they don't provide to everyone else. Then finally, there are other community-based programs outside of the ones I just mentioned. Here you have to be careful because they have to have an expertise in treating the specific conditions called for in the statute. So if you're not well qualified in the area of PTSD, TBI, sexual trauma, and so forth, then you cannot use them. So let's move on now to talk about monitoring the defendant. Here I think it's really important to understand for us as judges that there's a big difference between deferred entry of judgment, DEJ, that we know so well, has been around so long, and military diversion. DEJ is primarily supervised outside of the court. It's probation normally, and we have very little to do with it other than to determine whether people have failed or never participated or they've completed, and we generally, in many courts, just sign papers to terminate diversion and don't get much involved with it. With military diversion, you really have to be involved. There needs to be progress reviews. Because every month, you need at least every month, and often in the beginning, I suggest you should see them every 2 weeks. Because you have to get them in this program and get them through it. Our district attorney feels very strongly that if individuals don't take advantage of the program, they shouldn't be allowed to continue. And so often, even in DEJ, people are allowed to sit around and wait for months before they do anything. And the only way you're going to hold a hammer is by holding reviews. And they should be frequent enough so that you can say that this person is or is not participating and is or is not benefiting. And at the review hearing, do you use incentives and sanctions? I suggest you, sanctions are pretty much out of the picture. I would say 100%. If they're not progressing, you simply return them to the court and the matter, criminal proceedings are reinstated. Incentives can be helpful, but I find in working with those who have served in the military, they're just seeing you and being encouraged and being told they're doing a good job or they're failing and this is what they need to do differently can be very, very effective. You do need to get written reports from whoever is providing the treatment. The reason is, if this does come to a hearing, you need to have some basis for these determinations you're making that the individual is progressing in treatment. And the Veterans Administration is often the most difficult agency to get written reports out of. They do not have to be long, but at least you should have a place you can go to get a more detailed report. Finally, the length of diversion is 1 year, and you need to stick to that. I suggest it can be 2 years. But these cases, at least in my jurisdiction, I receive so many for supervision where there's serious cases with victims or the charges are serious misdemeanors that I want to get them through it or out. Let's turn to termination of diversion. Again, here it is a call by the judge who is supervising, and I look at it very simply, and I just suggest that are they doing anything at all? If they don't do anything at all, in a very short time, I terminate it because it is not fair to the prosecutor to leave them waiting 6 months to find out what happens, even though the statute says you only need to see them once every 6 months. If they're doing fine, you leave them in the program. I would never terminate them, and I wait to see how they progress. Now, if you are going to terminate them, you should state the reasons on the record, and you need to remember one thing: even if you're a Veterans Court, This is an area where they have an absolute right to a hearing, and it's a notice hearing before you can terminate them. Again, I suggest a collaborative model. I've terminated the individuals, never have been required to have a hearing, because the district attorney and public defender have, or the defense attorney really, see that the defendant as well as I see the defendant is not benefit. Supervision on the diversion, let's talk about completion now. What does it take to complete? Well, here, I think, again, it's going to be up to each judge. A lot of discretion is granted here, because you make that call. But I think what you have to look at least what I look at, is this. So many of these individuals coming back, let's say from Iraq, Afghanistan, or even those from Vietnam, and I have some of those who have been diverted, they suffer from conditions that don't go away. I mean, we have studies that show from Vietnam, 30 years later, people still have PTSD. These are not curable conditions. And so we have to be patient. So what do you look for? What I look for, are they making progress? Are they seeing their psychiatrist? Are they taking their medication? Are they going to the neurologist? Are they going to their outpatient substance abuse classes all the time? In other words, not this thing, I'm going once out of 6, but I'm going to them, and I'm making some progress. If they're making some progress, that's what I look for. And the second thing is, what happens after they are granted a completion and a dismissal? Substance abuse, as we all know, doesn't go away. Mental illness doesn't go away. Do they have an ongoing plan to continue to see the doctor at the VA or wherever they're getting their treatment? If I'm satisfied they're doing that, and it is not something that happens within 6 months usually, and I have many individuals in my diversion program, it's generally close, it is the 1 year, I'm going to then make that call, and if I find completion, I then make the dismissal, and remember again, of course, that they are entitled to a hearing. In a collaborative court, you usually don't have any objections from the people, but you should make sure you state the reasons why you are granting the dismissal. So I'm going to stop there, and are there any questions?
And please unmute your phone to ask questions.
Okay. Now let's move on into the implementation and give you 2 examples.
All right, so the next segment is some specific comments about program implementation, and we're going to briefly talk about the Santa Clara County sort of experience in implementing program, the Orange County experience implementing program, and then really what we're looking for at this point is the input from other counties of varying sizes as to what they've encountered or are encountering in getting this statute off the ground. We're very cognizant that how this program is implemented, or rather how this statute is implemented, is going to really be dependent upon sort of the size of your county, the experience with Clara, of course, in general, your experience dealing with veterans issues, and the resources that are available in your county, and how you overcome those particular problems. So let's start with Santa Clara County and what Santa Clara County's experience was and how their particular program works. Judge Manley.
Okay. So, and again, this is just an example, and our county, what we chose to do, and this was not a decision by me, but by the presiding judge, was to proceed in a collaborative manner and bring together the district attorney, the public defender, the defense bar, the Veterans Administration, and sit down and see if we could develop a protocol, and that's exactly what we did, and we did it fairly quickly. I can suggest this, if you are a county where you do have stakeholders who will sit down and talk with you, because what we came up with is working for us, and it was necessary to do this because we have so many, being a large court, we have a lot of judges who are granting diversion on a weekly basis, and we really needed a good protocol. So what happens is the defense attorney, usually a public defender, identifies those cases coming off the arraignment calendar where they're advised of their rights to this program, and they then take that information directly to the district attorney. We require in our protocol that the defense attorney and the prosecutor will collaborate to see if both parties would jointly recommend to the court participation in military diversion. Surprisingly enough, there was a great deal of agreement between the DA and the public defender, and that includes domestic violence and driving under the influence. At times there was no agreement, but there's a lot more than I ever expected. The protocol also provides, and something I strongly urge you to take into consideration, that every effort has to be made and taken to preserve the medical privacy of the veteran who seeks to participate. And then we cover the whole area of what does it take to show that you are eligible. And I'll just give you our list. A letter from a treatment provider stating you're being treated for one of those conditions stated in this statute, a redacted 1017 report, a redacted report from an expert stating the above, a redacted report from the VA, and then the next part of the protocol is important, I think, as well. The prosecution agrees that any evidence provided by the defense for the purpose of establishing eligibility will not be used against the defendant for any purpose. And any document given to the district attorney is returned, because it's a complete sharing of the document with the redaction, must be given back to the defense attorney. And if they stipulate that the defendant is eligible and suitable, then the judge grants diversion. If they do not stipulate, then we have a hearing. If the judge then, in his or her discretion, grants diversion, the case is transferred directly to the Veterans Court for Supervision and treatment. So that is the protocol we use in our county, and let me turn it over to my colleague.
All right, with respect to Orange County, we were fortunate when this statute was passed to have had a long-standing veteran treatment court overseen by Judge Joseph Perez. So when the statute was came into effect and we started looking at it, we gathered together the usual suspects to discuss how we were going to go about implementing this particular statute. Those individuals meant our Veterans Center people, our VA representatives, the VJO, our behavioral health, county behavioral health individuals, veteran services individuals, and we discussed all of sort of the issues that are associated with them, receive their commitment to assist and provide the service piece to our the individuals, also to perform or at least make themselves available to assess individuals who at that juncture perhaps had not had a specific diagnosis of any of the listed conditions. In terms of how the program works in our county, we have sort of divided up the labor, so to speak, and the decision to divert the defendant is a decision that is made in our limited jurisdiction justice centers. We've got 5 limited jurisdiction misdemeanor criminal courts in Orange County, each with their own pretrial and arraignment calendars and all of that. And those are the judges who are making the decision as to whether or not to divert the individual. We do not have the level of cooperation that Santa Clara County enjoys as between our prosecutors and our defense bar and our public defenders. most of the request to divert an individual made on behalf of the defendant was made by way of notice motion and full hearing and opposed to varying degrees by the prosecution. Now, the reason that we, although it may be ideal for the reasons described by Judge Manley, to have the same judge who supervises the veteran also make the diversion decision, this was purely a matter of resources. Judge Perez, who handles our veteran treatment court, also handles an entire panoply of other collaborative court programs, and he did not have enough hours in a day to be able to entertain the diversion motions under his calendar, so we spread them out throughout the county. Once the diversion decision is made, once the judge says, okay, I am going to divert this individual, then they get sent to Judge Perez to supervise while the individual is on diversion, to monitor their progress or lack thereof, to make the decision whether or not to terminate the individual or to find the person has successfully completed the program. This is not, the individual is not in the Veterans Treatment Court per se, but we felt that Judge Perez was the best person to supervise and oversee these individuals, one, because of his overall experience dealing with veterans and their particular issues, and secondly, because he had the team in place through VA and Vet Center and other professionals in place to be able to set up treatment programs, provide for reporting streams, and those types of things. So that's sort of the Orange County model. At this point, what I'd like to do, and if we don't have responses, then maybe what we'll do is volunteer some individuals, and that is try to get a sense as to how other counties go about their 1001.80 programs. Any volunteers out there? Is Alameda County, is there somebody from Alameda County out there?
So this is Gordon Rankin from Alameda County. You just asked if someone from Alameda County was here, and the answer is yes.
Right.
Can you describe what
questions, though?
Well, Gordon, can you describe what you're doing in your court?
Well, Steve,
Or military diversion?
We already had, as of 2 years ago, a collaborative court, a veterans court, for felonies only. We have read the statute that you're discussing now, and we have all looked at one another and said, what are we going to do to comply with the statute? Frankly, as far as the specific statute goes, Stephen, we have taken steps to have the same judge who handles our Veterans Treatment Court handle the 1001.80 court. I don't know if that's happened yet, so that's why I really can't give you that much of an update, Steve. I can tell you what we are doing now. We are handling these matters, and generally, as of now, they are coming through our drug court, and I am the drug court judge. But we haven't come up yet with a specific program that we have implemented, except to try to convince our Veterans Treatment Court judge to handle the 1001.80, and in the meantime, we've been getting veterans cases, sending them to our drug court.
Thank you.
Thank you.
Judge Perez, do you have a question?
Yeah, can you guys hear me?
We sure can.
Hi, Joe.
Okay, I didn't know if you could hear me earlier because I was trying to get in, but we couldn't get, no one could hear us.
Oh.
In our court in Orange County, we do have, in addition to our judicial outreach social workers as part of our Veterans Treatment Court, the Veterans Administration has been very kind in presenting us with another individual that is specifically for 1001.80 to to oversee the treatment of each individual person in our program. So that gives me that, I tell the defendant, you were to follow the guidance of this particular individual as it relates to your treatment. So that kind of gives me a guideline as to how they're doing. But how long they're to be in the program, it's been very difficult for me to kind of come up with, obviously these things last a long period of time.
This is Judge Manley in Mendocino County.
Oh, good.
Question.
Go right ahead, please.
So, there's some controversy in our county with DA and public defender about whether, DUIs should be considered for military diversion at all. And I appreciate the information we got from you earlier. Assuming we do treat those as covered, is there any reason we shouldn't be ordering, for instance, a first offender or a multiple offender DUI program completion as a condition of military diversion? People aren't going to be getting their driver's license back, from the DMV if they don't comply with that requirement. And it also seems from both the public safety consideration and the fact that it's a bit of a stretch to allow DUIs to be on military diversion anyway, to not have a program like that be part of it. Has anybody considered that issue?
Yes, I have quite a few DUI diversion cases sent to me, and we do require them to take the class because the driver's license is a major issue. And we there's also testing. There are a number of things we do, and that's generally all agreed to by the defense.
Thank you very much.
Does that answer your question? I mean, in other words, it just seems to me you have to be because it's a stretch to take a DUI case. I think particularly if they're priors, you've got to go out of your way to make sure that what they would normally be mandated to do, they're doing.
Thank you very much.
How is Santa Barbara handling this? Is that Judge Carozza?
Yes, Judge Carozza from Santa Barbara. Can you hear me?
Yeah.
Yes, great. Yes, what we do is we have a standing Veterans Court that was established several years ago, and we have rolled in our diversion program into the Veterans Treatment Court. There's one judge in North County that handles it, one judge in South County, that's me. And we created, as was mentioned, we got all the stakeholders together, which were the same people that were mentioned. We got input with the DA and the public defender. We created a manual to guide us through the process. And we have we tried to model it after PC 1000 diversion with sort of standard dispositions, although as you point out, each case is different, but we sort of have a standard disposition catalog so that we can go faster. We have 50 people in our Veterans Treatment Court in South County, of which now 25 are diversion cases. So the diversion cases are growing very quickly. And that's how we handle it. We handle DUIs, first-time DUIs. We excluded second-time DUIs. But that's basically how we work now.
Thank you. Any other questions or comments?
Just a quick one. Have other judges found that the numbers in their Veterans Treatment Court have gone down as a result of 1001.80, and does that mean that they're opening it up to more serious type felonies, et cetera?
I haven't found that. Actually, it's increasing, and as diversion, because diversion is misdemeanors. We take a lot of felons. We have a lot of felons who are sent to us for the Veterans Treatment Court. We even did, as was suggested, if you're not going to grant the diversion with all the information you have at the time of sentencing, you may well want to consider that the offender is going to continue to reoffend if they don't get the treatment, and send them to the Veterans Treatment Court to be supervised there and placed in treatment. We get a lot of DV cases that way, where they are sent because they do need specific treatment that the VA in our area offers. for PTSD, which is generally the condition that most closely correlates with DD and in my experience. So no, our numbers have actually gone up because we know a lot more people coming into our system now who are veterans that have served in the military because of everything that has to be done in arraignment, in advising them of their opportunities to participate in programs.
Thank you. I have a question. Okay, my name is Jim Lombardo from Monterey County, and I did have a question. Is there any thought on the court itself making a call as to what offenses get diverted and what offenses don't get diverted? In other words, we wouldn't open it up cooperatively to the DA and the public defender. We would just make the call off the get-go. Any problem with that? Any thoughts?
Frankly, if you're talking about a hard and fast list, I think that there would be some issues having to do with judicial independence and the exercise of judicial discretion in making that decision. The statute itself, as we know, doesn't restrict or exclude any misdemeanor offense. So it seems to me that to establish a court-wide policy that we're going to exclude, let's say, third-time DUI as a hard and fast rule, I'd be concerned a little bit from an independence and judicial independence standpoint and some ethical issues that might be involved in that. I don't know what Judge Manley thinks.
I agree completely, and it's even reinforced if you read the statute, because the statute, again and again talks about due process, hearings, notice, and things like that. And I think if you try to establish a rule to exclude DDs and DUIs from diversion, that to me would not work.
There was another question, I believe.
Well, you answered it.
Okay.
So I don't think it's improper.
Yeah, there's no misdemeanor offenses that are included, including sex offenses.
That's correct, and I've had referred to 314. I mean, it's the way, and actually, if you look at some of the research of those coming back from OEF and OIF, they're seeing a lot more sex offenses being committed by that group.
That's not to suggest that I think that they should be diverted. Right. As a matter of course. As a matter of fact, I had a 314 case that I denied diversion on because I didn't think that it was appropriate in that particular instance. I just believe that it's an issue that deals with the independent discretion of the judge.
Absolutely.
I have one with a sexual court with a minor and different sexual offenses with a minor, and I'm trying to think of that causal connection you mentioned earlier.
This is Clara from Fresno County. How are you?
Hi.
Judge Clara. I had a question. I know we were discussing taking the DUI class with any type of DUI, the different levels, 1, 2, for the multiple offender DUI program. With respect to, because it seems like none of the cause of actions are excluded in this diversion program, any of you would you have to obey along any conditions of remaining in the diversion program, in addition to interlock devices, AAs while you're waiting? Because it's a process. It doesn't happen the next day that they're in the program. Any suggestions for that type of treatment? Or from the court standpoint, supervision from the court standpoint?
All I can tell you is from my experience, and again, I do not make the decisions to divert. They're made by other judges. But when, under our protocol, when a judge diverts someone under military diversion, they can set conditions of pretrial release, because it's still pretrial. And often they will include conditions that you're discussing, particularly testing, and they are not going to be able to keep their license or obtain a license if they do not complete the
the alcohol program. So, yeah, that's stipulated to, by the prosecution and the defense. So it becomes part of their diversion plan.
Does that include the alcohol monitor and home detention aspect of it?
Yes. Very often, because the benefits of military diversion are so great to the defendants, they will often stipulate to all of that.
Thank you so much. We are out of time for this webinar. We appreciate all of the questions, but there will be opportunity for you to send questions to both judges. Their email addresses are on the screen, and feel free to email them your questions. Also, we mentioned Veterans Choice Program, and we wanted to put that up for you so you can also, if you wanted to contact or get us information, that is the Veterans Choice Program. There's the contact information where you can also get in contact and get the additional information. From time to time, after webinars, there are more questions that you might have, even our Criminal Justice Office staff. If you have questions for our Criminal Justice Office staff, please contact me, Michael Roosevelt, or michael.roosevelt@jud.ca.gov. Again, michael.roosevelt@jud.ca.gov. Thank you very much, and have a good day.